federal judge's ruling overturns Prudential's improper calculations of a disability policyholder's monthly earnings. Look, once a disability carrier accepts a claim, they are going to try to figure out how to pay you as little as possible. So how do they go about doing that? Well, the calculations start with the policy definition of base earnings. Many policyholders are surprised to learn that base earnings is generally just that. It's the base with no commission, bonus, overtime, or any other extra compensation. Ouch. But what happens if the policy doesn't define those terms? Does the carrier get to define those terms in a way that benefits them and screws the policyholder out of desperately needed benefits? After all, the policyholder has established a lifestyle based on all of their earnings and not just their base pay. Well, let me tell you the story of Mr. Jantos. I read cases across the United States, and this is a great case. In this case, Prudential had calculated his base salary at $190,000 per year, and they divided it by 12 to get a base earnings of $15,833, and they paid 60% of that, or $9,500 per month. But guess what? The employer confirmed a base salary of $190,000. The W-2s showed he earned $690,462 for 2010, $716,595 for 2011, and $598,000 for 2012. Using a de novo standard of review, the court noted that the only type of evidence in that file concerning the monthly earnings was the monthly base earnings, and that Prudential believed that it needed only to determine the annual salary in order to calculate the monthly earnings. But the court noted that the plan didn't explicitly have any language limiting monthly earnings to the annual base salary, but they felt that it could be calculated based on the gross monthly income, excluding income earned from commissions, bonuses, overtime, or any extra compensation. None of those more specific terms were defined in the plan. Under the doctrine of contra pro forentum, the court is allowed to interpret any ambiguities in favor of the non-drafting party, in this case, the policyholder. The court found that based on an affidavit from Mr. Jantos, there were potential sources of income that should have been considered, including the income he received as a shareholder and passed through on a Schedule K-1 return. And that could not be dismissed as discretionary bonuses or extra compensation. Now, the court rejected the argument that since these monies were not paid monthly, they couldn't be included in the calculation. That's a disability carrier type argument. But what the judge did was remand the case back to Prudential to determine the correct amount of Jantos' monthly income. Now let's hope that Prudential got it right this time and gave him the benefit of all of the income that he was receiving at the time he became disabled in calculating that that base earnings. What are the lessons learned in a case like this? Well, there are many lessons. First, you should read the disability policy before you stop working and apply for benefits, so you understand what the base earnings number is, because all the calculations are going to start from that number. Number two, if the policy is clear about what's includable and not includable, get out your income information and start adding up what's includable. Now, that will be the number against which your benefits will be calculated. The third thing you need to do is, if the policy is silent about what's includable or not includable, I think that you should immediately hire an attorney, because this is going to result in a battle. But two, you want to make sure, if possible, you can get a statement from your employer about what they consider to be your base earnings. And that's particularly true if you're involved in a situation where you're a shareholder or you're getting other sources of income that should legitimately be included in your base income. You'll want to get an affidavit from your employer regarding that, and you may also want to get an affidavit or documentation from your accountant justifying the inclusion of those monies, such as K-1 partnership monies, in the base earnings. You can see that this is a very complex issue, and one that hopefully you are able to reconcile and solve with the carrier. But quite frankly, you should obviously try to fix it before you apply for benefits. But if you can't, you really do need the assistance of an experienced ERISA disability attorney who can help develop the kind of evidence that I just outlined. I help people across the United States get the disability benefits they deserve. So if you have any questions about your rights to benefits, the calculation of your benefits, or you want to appeal a wrongful termination or denial of your claim, call me today at 727-894-3188 for a complimentary consultation. I can help you get the right amount of your disability benefits that you deserve and your family has come to depend on. I look forward to helping you.